Hello, I'm so glad that you have joined us for this webinar on alternatives to the H-1B lottery. If you are here, it is likely because you or your employee were not selected in the H-1B lottery this year. And if that's the case, I am definitely sorry to hear that, but know that there are options beyond the H-1B. As always, the information presented in this webinar is for informational and educational purposes only and is not legal advice. If you have questions as we go throughout this webinar, feel free to put your questions in the comments below this video, and we are happy to address them if we can. Keep in mind, we can't give legal advice through comments like that. We have to do that in a consultation or an attorney-client relationship, but we're happy to answer general questions if we can. So an overview of what we're going to talk about in today's webinar on alternatives beyond the H-1B. First, just a brief overview of what is the H-1B lottery, what are this year's results, and I am filming this in April of 2025. What are the overviews of other options, or what is the high-level overview of other options, and then strategic considerations and next steps. So to begin with, what is the H-1B lottery? The H-1B lottery is, as the name implies, a lottery for the selection of H-1B visas. So to back up for a little bit, the H-1B visa classification is a type of U.S. immigration visa classification for professional positions. A U.S. employer has to sponsor a foreign national worker for the H-1B position. When I say professional positions, the regulations indicate that that's an occupation or position that requires a minimum of a bachelor's degree in a specific field of study to enter that particular occupation. The H-1B lottery comes into place because there is a limited number, in general, there's some exceptions we'll talk about, but a limited number of new H-1Bs available every year. Specifically, there are 65,000 new H-1Bs available every year, plus an additional 20,000 for U.S. master's degree holders or higher. So there are so many people every year who want a new H-1B that there is usually a lottery. For the past several years, there has been a lottery that is conducted at the end of March. So the system is that employers register their foreign national employees or prospective employees in the H-1B lottery. That's called submitting a registration. That's typically done in March for about a 2.5 to 3 week period in March each year. At the end of March, USCIS selects the petitions or selects the registrations to meet that annual numerical cap of 65,000 plus an additional 20,000 for U.S. master's degree holders or higher. So the lottery is conducted at the end of March by March 31st every year. Employers and their attorneys are notified. We in turn let the employees know, or the employers let the employees know, the selected beneficiaries know. They may not be employees yet. And then we can file the H-1B petition, the cap subject H-1B petition, between April 1st and June 30th. The H-1B status does not become effective until October 1st of that year. That's by regulation. The regulation indicates the H-1B status. That's when the fiscal year starts for USCIS. So that's when the H-1B status will become effective, assuming that the H-1B petition is approved by then. So that's the lottery. This year's results. So today is April 4th, 2025. We don't yet know exactly how many registrations were submitted in March 2025 for this year's lottery, but we do have the selection results, at least for the first round. So in our office, we had about a 40% selection rate, which is amazing. Last year, the selection rate and year before that was about 26%, and it was even worse in previous years. So we're really, really pleased with that. I have talked to a number of other immigration attorneys across the country, and they're seeing a similar selection rate. So we're really excited about that. It is possible, keep in mind, that there will be a second lottery later this summer. So sometimes that happens. It did happen the past 2 years. If USCIS does not receive enough petitions between April 1st and June 30th to fill the slots available, the 65,000 plus the 20,000. So in the past 2 years, they did not receive enough petitions during that first round of selections. And so they did a second lottery in the summer, in July. If that happens, you only are eligible for that second lottery if you registered in March. So if you have not yet submitted an H-1B registration, an H-1B cap registration for the lottery, then you do have to wait until March of 2026 or whatever the following March is to be registered in the lottery. You can't in June say, oh, in case there's a second round, I want to go ahead and register. That's not how it works, unfortunately. But if you were already registered, it is possible that there will be a second round. It's possible that there will not be. And USCIS will announce when they have officially met the cap and if there's going to be a second round or not. So we expect that this summer if there's going to be a second round. Anyway, how was this year different? Again, I said the selection rate this year was around 40%, whereas last year and year before it was around 26%, and years prior to that, it was even lower. I think two big differences this year. One is that the USCIS registration fee jumped from $10 per registration to $215 per registration. That's a huge jump, obviously, and I believe that it eliminated what I call tire kickers, or people who were just submitting an H-1B registration just to see, just for the fun of it, and maybe not quite taking the process as seriously as others. So I think that is a big factor. In addition, I think the beneficiary-centric selection process also has made a big difference the past 2 years. By that, I mean starting last year, and it happened this year as well, so this is the process going forward. The selections are made based on the beneficiaries, meaning the foreign nationals' unique passport number. So that means that if John Doe, for example, let's say he's a foreign national entered in the H-1B lottery, if John Doe had 5 different employers that were willing to submit a registration for him, if John Doe's passport number was selected, then John Doe was counted once. And any one of the 5 or multiple of the 5 employers that submitted a registration for him could file an H-1B petition for him. In years past, before last year, the selection was done in the opposite way, meaning before last year, USCIS would select the registrations based on the employer. So if employers A, B, C, D, and E submitted a registration for John Doe, employers A and C, for example, could have been selected, and that would have taken up 2 slots for John Doe. So if you don't understand that, don't worry about it, but just know that the registration system is now beneficiary centric, and that is really to the advantage of everyone. It's a win-win, because if a person enters through multiple employers, that does not mean they take up multiple slots. So that's good. That's a good thing. So that's how it is different this year and last year as compared to previous years. So before we move to the actual options beyond the H-1B lottery, let's think about some strategic considerations, some things that I always encourage clients or prospective clients to think about as they're thinking about options apart from the H-1B lottery. The first is, what is your current immigration status, or your employees' current immigration status? So we'll talk about different options if you are here on F1. You may have different options if you're here on a dependent visa, such as an H4, L2, any number of other dependent visas. Also think about what your long-term goals are here in the United States and beyond, potentially beyond the United States. Personally, I love foreign nationals. I think they add so much to the United States. I think that they are an amazing way to add, not way, people aren't to means, but I think that having foreign nationals here in the United States adds such diversity and culture and all wonderful things to the United States. They're very, can be very entrepreneurial, and they add jobs to the US workforce. So all good things about foreign nationals. So I want you all to stay here. But there are some people who are just here for a limited period of time, and that's okay too. So think about what your goals are. If your goal is to come here to earn a US master's degree and perhaps work for a year or two and then go back home, that might be doable without having to worry about the H-1B. In other situations, a foreign national does want to stay here longer term, and they want to work and stay here and get work experience. Perhaps they want to stay and eventually apply for a green card. So think about what your strategic long-term goals are, and those may change over time, and that's totally fine. And then finally, think about how feasible are your options. Again, we'll talk about different options in just a minute, and they all have different probabilities or possibilities of working depending on the option itself, but also depending on your specific individual situation, what your current status is, how much time you have. Sometimes it depends on your nationality, things like that. So think about how feasible are your options, how much are you willing to risk, and what are you willing and able to invest in terms of time and resources. So let's get started. The high-level overview of other options is there are non-immigrant visa classification options. When I say non-immigrant visas, I'm talking about temporary visas. Temporary in this case can mean years. So just because we're talking about a temporary visa classification does not mean, oh, it's gonna, get you another 6 months in the United States. It can last for years. So we'll talk about some non-immigrant visa options. We'll talk about some permanent residence options and then remote work considerations and strategies. So let's go ahead and get started with the non-immigrant visa options. One of them, the very first one we're going to talk about is the H-1B cap exempt option. So we spent all this time so far talking about the H-1B lottery and how there is an annual numerical limit on the number of new H-1Bs, and that is true. So when I say new H-1Bs, that does not apply to transfers, extensions, amendments if you've already held H-1B status. In addition, there are some organizations that are cap exempt. That means that they are not, if this particular type of organization, qualifying organization, sponsors someone for an H-1B, that particular H-1B petition is not subject to this annual numerical limitation, and so you don't have to go through the H-1B lottery. Those institutions or those organizations include institutions of higher education, so universities and colleges, nonprofit entities affiliated with or related to institutions of higher education. So that would be, for example, it can be something like a nonprofit organization that has a memorandum of understanding with a university to host students for learning opportunities. So for example, I have represented a nonprofit dental practice. So again, nonprofit is key here. That has a memorandum of understanding to host dental residents. So the dental students come from that university to the practice to have a hands-on experience. So that's one example. There are other examples as well of how you can have that qualifying affiliation or relationship. Other types of organizations include nonprofit research organizations and then federal, state, or local government research organizations. So one thing to keep in mind when we're talking about cap exempt organizations, a lot of people come to me throughout the year and say, hey, I have a job offer from a nonprofit organization. I want to get an H-1B. That's fantastic that you have this job offer, but remember, it's not enough just to be a nonprofit organization. It has to fall into one of these categories. But it is possible to do. Within this option of H-1B exempt organizations, there's kind of a further, kind of more advanced strategy, and that is a concurrent H-1B. So concurrent H-1B just means that a person holds an H-1B with employer A and employer B. The strategy that I'm talking about here is it is possible for a person to hold an H-1B cap exempt petition, okay, with a cap exempt organization, let's say a university, for example, and at the same time have an H-1B petition through a cap subject organization, even though they haven't been counted against the annual numerical cap. So they haven't been selected at least in the H-1B lottery. For this to work, the foreign national has to continue working for the cap exempt organization. And you can work, like I said, for the cap subject organization at the same time. I've had numerous clients over the years who have taken advantage of this, and it's worked really well. One thing to keep in mind is you have to keep working at the cap exempt organization for as long as you hold H-1B status, unless you go through the H-1B lottery and you're selected there. And that happens too as well. But my point is you can't get an H-1B petition through a cap exempt organization, have a concurrent H-1B with the cap subject organization, and then stop working for the cap exempt. If you do that, you're no longer eligible to work for the cap subject until and unless you go through the H-1B lottery and you're selected there. So I've had this, like I said, have had numerous clients over the years who have had this situation. They have been able to take advantage of this particular type of filing. One consideration or one question I get a lot is how many hours do I have to work at employer A versus employer B? And the answer is it depends. So it depends on what your arrangement is with both employers, and it has to be viable, it has to be believable. So if you were to say, hey, I'm going to work 1 hour a week for the CAP exempt organization, or 1 hour a month is a more extreme example, but even 1 hour a week with the CAP exempt organization and then 39 hours a week with the CAP subject. That's probably not going to fly because USCIS wants to see that it's a true job offer with the CAP exempt, but there's no bright line test here. I have had clients who have worked 10 hours a week at the CAP exempt organization and 30 hours or whatever the number of hours is at the CAP subject organization or vice versa. So it really depends on what you have worked out and what is viable with USCIS. A more even more advanced strategy for this particular within this particular scenario is I have had clients over the years who have done this. They've had a concurrent H-1B with the CAP exempt and CAP subject. Usually the CAP subject organization is my client. And they have coupled this with the green card process. So in other words, they typically what has happened, and this has happened for several of our clients, is they have the CAP subject organization has submitted registration, they haven't been selected, and so they start the employment-based green card process, which we'll talk about in more detail in just a minute. So they start the employment-based green card process and at the same time to be able to keep working because, and we'll talk about this, but submitting, depending on where you are in the green card process, just starting the employment-based green card process itself is not enough to allow you to stay in the United States and to work. So in order to keep working and be able to stay in the United States, these clients have had a position with the CAP exempt organization and the concurrent H with the CAP subject. They keep working through that arrangement while the green card process is playing out. Once they get the green card, then they work pursuant to the green card for the CAP subject organization. They no longer have to work for the CAP exempt organization. They can, but they don't have to. So that is a more advanced strategy, but I've done this several times for clients and it's worked very well. We'll talk in a few minutes about the visa bulletin and how situations where this may not work as well. If you were born in certain countries, there's a longer wait for a green card, and this is not going to be a viable solution probably. But for a lot of people, it is potentially. So moving on to the next non-immigrant visa classification, we'll talk about the F1. So a lot, not all, but a lot of people who are registered in the H-1B lottery are already here in the United States. And by the way, you can be entered in the H-1B lottery even if you are living outside of the United States. We've had lots of clients who are in that situation. So anyway, a lot of people who are registered in the lottery are here on F1, which is the International Student Visa Classification. There are options if you hold F1 status. There are options to potentially keep working. And there are options to potentially stay in F1 and study, but not necessarily work. It would allow you to stay in the United States. So we'll talk about each one of these in turn. The OPT, the optional practical training, OPT stands for optional practical training. In general, OPT is available after an F1 student graduates from a degree program. OPT allows that F1 student to work in the United States for up to 12 months in a field of study that's related, or in a position rather, that's related to their field of study. So that can be a way to stay in the United States every year. Just it depends on when you're graduating and just where you are in the immigration process overall. But every year we have people who are just about to start. They haven't even started maybe they haven't even graduated yet, and they're about to start their OPT. If that's your situation, then and you're about to start OPT, it's entirely possible that you could work, once you get the OPT, you could work. And then next year, next March, you're still working and you could be registered in the H-1B lottery. So that is absolutely a possibility. The pro of this, one of the pros of this, one of the advantages is, as I just said, it buys you more time. You have more time to register in the H-1B lottery again next year, potentially begin the green card process, or implement another one of these options that we're talking about. In addition, it's possible to take advantage of CAP gap. So the H-1B cap gap provision is in the regulations. It says that if your OPT is going to expire between the time that you file the H-1B petition and October 1st. So remember, your H-1B status cannot be effective before October 1st or until the petition is approved, whichever's first. So if your OPT is going to expire between the time you submit your H-1B petition and October 1st, if you meet certain requirements, and those requirements are that you file for a change of status instead of consular processing. So it's a box that we mark on the petition asking USCIS to change your status from F1 to H-1B. So you have to request a change of status. You have to timely file the petition, meaning you have to file it within the filing window, of course, and you have to file it before the OPT expires. So if you meet those requirements, and as long as the petition is either pending or approved, if it's denied, the cap gap is cut off. But as long as it's pending or approved, you have cap gap, which means your OPT is extended until April 1st of the following year, which is fantastic. It gives you a lot of time to keep working, gives you time to get that H approved, and there's not an interruption in your work authorization. So that is a really good thing with that. And so that's the reason that I said, if you are, let's say that you're in a situation where you're about to graduate and you're lucky enough to have an employer to register you in the H-1B lottery even before you've graduated, that's fantastic. Then you could you could register the next year. And if you're selected, depending on when your OPT ends, take advantage of this and keep working without interruption. This is one reason that I always say to people, register as early and as often as you can for the H-1B lottery, because you just don't know if you're going to be selected or not. So sometimes I'll talk to people, potential clients or clients who say, oh, I'm not going to register this year, or I'm not going to register my employee this year because I know they're eligible for STEM OPT, so we have time. And, it's definitely up to the clients, the employer and the employee and there are other considerations as well, for sure. But from an immigration perspective, I say, please consider registering the first year that you are eligible for it, because you could not be selected this year. And then you'd be able to register the following year or the following year. But if you are selected, then you have options. So that's my spiel on registering as soon as you can and as often as you can. So the cons of OPT, the disadvantages, it's only available for 12 months. We'll talk about STEM OPT in just a minute. Beware of unemployment. You have 90 days of unemployment as a maximum, and be careful of unpaid internships for at least two reasons. One is employment law. I don't practice employment law, but you want to make sure, especially as an employer, that you are not violating any employment laws by not paying someone. And then B is, I have seen situations before where a foreign national will have an employer give them an offer letter saying, yes, or a letter of employment saying, yes, we're employing you, and then they don't actually work. That's not okay. That's fraud. It can be considered fraud or misrepresentation, can cause massive problems down the road. Don't do it. It's a big problem. So be aware of those things. The STEM OPT is it's optional practical training like the first 12 months of OPT, but it's an additional 24 months of OPT for students whose field of study is in science, technology, engineering, or math. There's a list. Okay, so if you want to take advantage of this, make sure that your SIP code, C like cat, I like India, P like pig code is, I think that stands for Curricular Instructional Program code, is on the list of approved STEM fields of study, because not every field of study that you would think would be eligible for STEM is on there. So I've had dentists and veterinarians whose field of study is not on the list. They're not eligible, so check it. But if you qualify for the STEM OPT, you get an additional 2 years to work on OPT, which is fantastic. Like I said, you have to have a field of study that falls, is on the approved list. You have to be in a period of active post-completion OPT to request it. You have to be working for an employer who's enrolled in E-Verify, and there is a training program requirement. Personally, I don't think it's a big requirement. It's not overly burdensome to complete, but there is that additional requirement. So the advantage of STEM OPT is that you have more time to work. You have an additional 24 months. So that means potentially 3 years total, including the 12 months of original OPT. So you have more time to work and implement another option, whether that's registering again for the H-1B lottery, starting the green card process, or implementing another option. Possible drawbacks of the STEM OPT are you have to be paid. You have to work at least 20 hours a week for each employer. You have to have a training plan. There are reporting requirements for both the employee and the employer, and the unemployment limit is 150 days combined with your OPT as well. So the next option of F1, so we're still on F1, okay, classification. We'll talk about other non-immigrant visa classifications in a few minutes. But within F1, there's something called curricular practical training. That is an integral part of an established curriculum. It is available when a program, meaning a course or a series of courses that you are taking as the F1 student, require a hands-on experience, like an alternative work study situation, an internship, a co-op, or an externship, some other practical hands-on experience. You have to have a cooperative agreement. The employer has to have a cooperative agreement with the university. The training has to be related to the field of study, and you have to have been enrolled full-time for at least 1 year. There is an exception to that, which is for day one CPT. In that situation, the CPT starts immediately. And this is an exception for graduate level study students where immediate participation is required. There's certain regulatory requirements that have to be met. So the advantages and disadvantages of CPT, just in general, I list day one CPT here, but just in general, whether it's day one CPT where you start the CPT immediately, or if it's not, if you have been studying for a while, let's say a year, and then you start CPT, either way, there's some pros and cons to this. The advantage is it potentially can be a way to work if used correctly. The disadvantage or potential disadvantage is that 1 year full-time CPT, if you work for 1 year full-time CPT, that means when you graduate, you're not eligible for the post-completion OPT, that 12 months of optional practical training. In addition, if you work on CPT, especially if it's day one CPT, but just in general, if you work on CPT, it can raise a red flag for USCIS when a student changes status. So that means when you change status from F1 to H-1B or any other visa classification, and or when you go to apply for a green card, and it can be misused. There are certain universities that are well known for just freely issuing CPT, and especially day one CPT. They seem to have a very liberal interpretation of the regulations and or potentially not care much about the regulations. So just be careful if you're using CPT. You want to make sure that it's done by the book, that it's done per the regulations, that it's done correctly. And it can be a great way to have a very meaningful hands-on practical experience through an externship or co-op situation, but it can be misused. So be careful with it. The final option under F1, this visa classification, is continuing on F1 without working. That may not be an ideal situation. You probably want to continue working or want your employee to be able to continue working. But every year we have clients not selected in the H-1B lottery who do decide to go back to school, perhaps to pursue the next level of degree, to perhaps sometimes to pursue the same level degree, but in a different field of study. That's rare because you're not eligible for post-completion OPT if it's the same degree level. But they go back to school and then they register again in the H-1B lottery the following year. If they're selected, let's say that you go back to school, start a master's degree program, and then you're selected that year, the year after you're not selected, then you could decide to stop that program, that degree program, or you could continue, but still file the H-1B petition. So you do have options. All right, now we're moving on to other non-immigrant visa classification options. For almost every letter of the alphabet, there's a different visa classification and different subclassifications within those. Every visa classification has a different purpose, different requirements, different durations. So we won't go through the entire alphabet, but there are some, I think the most appropriate, the most highly used visa classifications are here. That includes the E2. So the E2 is for treaty traders or investors. I am not talking about the EB-5 green card classification that requires an investment of over $1 million. That is potentially an option, but that's not what I'm talking about here. The E2 is a temporary visa classification, like I said, for treaty traders or investors. When I say investors, there's no minimum amount that you have to invest. My dog. It really depends on the particular project that you're engaging in, the particular business that you're either purchasing or starting up. So it can vary. It does not have to be $1 million by any means. The E2 is treaty based, so there does have to be a qualifying treaty between the United States and your country. And the other thing about the E2 is it can be used for employees. The company has to be majority owned by a person or a group of persons that have that same nationality. So, for example, if you were from England and want to work as an E2 employee, then the company that you work for has to be majority owned by English nationals as well. But it is a possibility for sure. There are several visa classifications that are country specific. So the E3 and H-1B1 are both very similar to the H-1B classification in that the process is generally similar, the requirements are similar, it has to be for a professional position. There is a limit on the number of new E3s and H-1B1s every year, but it's rarely, if ever, met. Yay, knock on wood. The E3 is for citizens of Australia. The H-1B1 is for citizens of Chile or Singapore. Likewise, country-based, the TN visa classification is for citizens of Canada or Mexico. There is a list of specific occupations that are eligible for the TN, so it's not quite as flexible as the H-1B, H-1B1, or E3, but it is a possibility. The L1 is for intra-company transferees. So there has to be an entity, a qualifying entity overseas. When I say qualifying, there has to be a qualifying corporate relationship between the entity overseas and the US entity. It is possible for the employer of this foreign national to transfer that foreign national from the overseas entity to the US entity. One of the requirements is you have to work overseas in that overseas entity for at least one of the past 3 years before you're transferred. But that is potentially a possibility, and we'll talk a little bit more about that in a few minutes. The J1 is used for intracultural exchange. It's used for all different things, including teachers, postdoc scholars, au pairs, interns and trainees. So there are a variety of uses for the J1 or appropriate uses, appropriate reasons to use the J1. You do have to be careful because you can become subject to the 2-year home residency requirement if you receive government funding or if your occupation is on what's called the skills list. So just keep that in mind that it's possible that it's a little bit more restrictive. Depending on the reason that you're using the J1, the duration isn't super long. For example, trainees and internships are not very long, so may or may not be helpful. And then finally, the O1 is for foreign nationals of extraordinary ability. So that means individuals at the very top of their field. There are specific regulatory criteria that you have to meet, but in general, it's for people at the top of their field in science, education, arts, business, athletics. So if you, for example, are a well-known in your field, and you don't have to be, Einstein by any means, but if you're well-known in your field and you have a number of publications, citations, you've presented at national and international conferences, that could be an option. And in fact, we have done that before, even recently, for an individual last year who was not selected in the H-1B lottery. Now he is happily working for his employer in O1 status. And then the dependent of spouse. This may be you already. You may already be in this situation, but keep in mind that there are a number of visa classifications that do allow spouses to work. And I won't go through all of them right now, but just know that that's an option. So for example, if your spouse is on L or J1 or potentially H-1B, there are certain requirements that have to be met. It is possible to work to get an employment authorization document, also E, on those particular visa classifications. So we're moving now to the second big bucket, permanent residence pathways. So we'll talk a little bit about the employment-based process. We will not really cover the family-based, the rest of these, the family-based process, diversity visa lottery, humanitarian, TPS, DACA, and parole, but know that those are potentially options. We handle family-based cases all the time. So whether it's marriage-based or you have another type of family member who's sponsoring you, we're happy to help with that. Send us an email, get on our calendar for a consultation. We're happy to talk to you about that possibility. The diversity visa lottery is, again, a lottery. You may say, Emily, I don't want to hear about a lottery ever again. I get it. But it is pretty amazing. The diversity visa lottery opens, the registration opens in October of every year, and only certain countries are eligible, as the name implies, to encourage diversity among immigrants here in the United States. You have to make sure that your country is on the list. Typically, people register for the diversity lottery on their own. And then a lot of times people do work with an attorney to actually apply for the green card because there's some logistics to work out there. Humanitarian, we don't handle that either. Asylum, U and T visas, know that that may be a possibility. And then TPS, DACA, and parole is in a lot of turbulence, let's say, right now. With the current administration, there's a lot of litigation going on about all of those, but it could potentially be an option. So let's talk in more detail about the employment-based pathways. There's several ways, several different types of employment-based permanent residence. The EB-1A is for foreign nationals of extraordinary ability. The criteria are similar to the O-1 that we just talked about a few minutes ago. They're not identical, but similar. Likewise, the national interest waiver, or NIW, both of those, the national interest waiver is for individuals who are working on an endeavor that is in the national interest of the United States. They have to show that they are well positioned to continue to succeed in that endeavor, that type of thing. For both of those, the EB-1A and the NIW, you can self-sponsor, meaning, or the employer can, but you don't necessarily have to have an employer to sponsor you for those classifications. They're not easy to get approved, okay? I'm not saying that you won't be successful, but a lot of times people, I don't handle them right now, this type of classification, but a lot of times people think that they're eligible or they've heard of, a friend's, neighbor's, best friend's, cousin's, ex-sister-in-law who was approved and think that they will be as well. So just make sure that you're talking with a qualified immigration attorney to get a good sense of your chances of success if you want to pursue that. The perm-based green card does have to be sponsored by a U.S. employer, and you will want to work with a lawyer for that, for sure. But that is a possible option. We do lots of those every single day for our clients, our corporate clients and their employees. And then there may be other strategies for permanent residents, like, for example, the EB-1C classification. So EB-1C is for, remember a few minutes ago, we were talking about the L1, where you can, the multinational transfer of employees, where a company that has an overseas entity can transfer an employee to the US. There is an analogous green card process for multinational executives or managers. Just like the L, you have to have at least 1 year out of the past 3 before you came to the United States of working for the overseas entity. So this actually, it sounds attenuated, but it is something that companies do as a strategy on a regular basis. They will have an employee here in the United States, they have an overseas entity, send them to work for that overseas entity for at least a year, bring them on an L, and then they could potentially qualify for this EB-1C green card down the road. So there are lots of options. One possible challenge with the employment-based green card process is that you may have to wait for a green card to become available, and that means it may not be a viable short or medium-term solution. So what I mean by that is there is a limited number of employment-based green cards available, specifically 140,000 every year. And that includes spouses and children. There's so many people who want a green card that there is a virtual line of people waiting for the green card. Your place in line, in that virtual line, depends on 3 things. Depends on your country of birth, it depends on your employment-based category, and it depends on your priority date. The priority date is this date that you see here, these dates that you see, for example, June of 2023. That is the date that the green card is filed. So typically it's the labor certification if we're talking about a perm process that I mentioned a few minutes ago. Otherwise, it's the I-140 if you're doing something like an EB-1A or national interest waiver, but it's the date that the first portion of your green card is filed. That sets your priority date. The employment-based categories, EB1A, as I mentioned, includes falls into the EB1, as the name implies, the foreign nationals of extraordinary ability. It also includes researchers and professors of extraordinary ability. Outstanding. The word is outstanding. Outstanding researchers and professors. Whoops. And then EB1C is for, like I said, certain multinational managers and executives. The EB2 classification is for positions, either national interest waiver. National interest waiver falls into the EB2 classification, or for positions that require a minimum of a master's degree or a bachelor's degree and 5 years of experience. The EB3 classification is for positions that require a bachelor's degree and 2 years of experience, and then other workers for anything less than that. And then finally, the third factor that plays into where your place in line is your country of birth. So not where you're a citizen, but your country of birth. So the regulations say, the statute says no country can take more than 7% of the overall allocation of green cards. We would have so many immigrants from these countries, China, India, Mexico, and the Philippines, that they would take more than 7%. So they have their own cutoff dates. So as you can see, if you look at the EB2 category, the India priority date is January of 2013. That means if you filed, and this is, by the way, the April 2025 visa bulletin we're looking at, if you filed the labor certification or whatever it is, if your priority date is before January 1st, 2013, a green card is available for you. Whereas if you were born not in India or China or Mexico or Philippines, the priority date is 10 years ahead. It's it's June of 2023, more than 10 years ahead. So that makes a big difference, unfortunately. So my point is, if you were born really in China or India, filing the green card, starting the employment-based green card process may not be a good short or medium term solution. Long term, it's great. You'll get there, but short or medium term, it's probably not going to be a viable solution. You'll probably need some other temporary visa classification in the meantime. And that may be true even if you weren't born in China or India, it just depends. So, but no, to go back to the green card process for a minute, let me tell you a success story about this. It is viable to do. I have told you already about the clients that I've had that have worked on a concurrent H-1B for a CAP exempt organization and CAP subject, and their employer started the green card process like immediately after they weren't selected in the H-1B lottery, the first round. And then they went on to work for have the concurrent H-1B, and then 2, 3, 4 years later, depending on the timing and a variety of factors, they get their green card. So that's one example of successfully kind of leveraging this option of permanent residence, the employment-based permanent residence option. Another example is I have several clients who have done this. They've registered their employees in the lottery, weren't selected. Their employees then go work overseas. This kind of goes to what the next topic that we're talking about, the final topic. They go to work overseas, and sometimes they work remotely for the employer while they're overseas. Sometimes they don't. They just keep on, keep in touch, keep that personal relationship going. And the employer starts the employment-based green card process. They keep registering that employee every year in the H-1B lottery. So there's one client in particular, this happened last year. We registered her in the H-1B lottery year 1. Okay, wasn't selected. The employer started the employment-based green card process. Registered year 2, wasn't selected. She stayed overseas, employment-based green card process keeps playing out. Registered year 3, not selected in the H-1B lottery. But there was a second round last year of the H-1B lottery selections, and she was selected. So she is now in the United States. So we filed the petition as of October. She was here in the United States and working in valid H-1B status, and she is well into her green card process. She's in a really great position to be here long-term with her employer. So it absolutely is doable. I know it seems daunting at first, and it seems really disappointing, of course, not to be selected in the H-1B lottery, but there are options beyond that. It is absolutely possible to get where you want to be. So our final topic here is remote work considerations. So you could, if you are an employer or employee, you could send your employee to work overseas remotely, at least temporarily. It might be that part of your strategy is the L1 visa down the road. So remember, that's when if you have a qualifying overseas entity, you have them work at that entity for at least a year and then come in. One note on the L1, there are requirements for that. There are a number of requirements for that, right? There are regulatory requirements for that. There also are unwritten requirements for that. The size of the company really matters. And if it's a really tiny company overseas and or here in the US, it's probably not going to work. I'm not saying it's impossible, but it's unlikely to work. So if you are interested in this option, please talk to us or another qualified immigration attorney before you pursue it to make sure that it's a viable option. I don't want anyone to go work overseas for a year and then find out, oh, that's actually not really going to work. It may be that an employee goes overseas for a period of time to let the employment-based green card process play out. I said that a few minutes ago, just a few minutes ago. I was telling you about the person who was selected the third year in the second round. Also, that happens with employees who just aren't selected. They either don't register year after year or they do when they're just not selected, but they do come to the United States on what's called an immigrant visa, which means they enter with and receive their green card as soon as they enter as a permanent resident. So that is a possibility. Again, if you were born or the employee was born in India or China, it's going to take years to get to that process. So that's probably not something you want to count on as your number one strategy. You can register, of course, in H-1B lottery again later. And it is possible, as I have implied in these stories that I've told, it is possible to pursue multiple options at the same time. So remember, the person who was registered 3 years in a row, there were multiple strategies, right? She was registered multiple times, they started the green card process, and she worked remotely for the employer from abroad. And then finally, this is a bit more attenuated, but people do it. I've had clients do it. You may work on citizenship for another country in order to pursue one of these kind of country-based options that I talked about. So I've had numerous clients over the years that have worked to get Canadian citizenship to get to be able to use the TN visa classification to come work in the United States. And then from there, it is possible to transfer to the green card process, even though the TN is not dual intent. And I have a video on that in our Sumner School Business Immigration Basics series, if you're interested in what the dual intent, what I'm talking about there. But it's possible to work on another citizenship. Like I said, I know that's kind of longer term and more attenuated, but people do it, and it is absolutely a possibility. If you pursue this option, the remote work possibility, keep in mind that there are some things that you're going to need to work through. There are potentially tax and payroll implications. That's beyond my expertise, but the employer needs to consult with somebody in that field who can help them navigate that properly. And then you may have visa concerns for a foreign country. If you're not going back to your home country, you may actually need a visa for wherever it is you're going to work. So we're circling back now, right? We're done with the options, and that isn't every option, of course, possible. I could go on for an entire day to talk about all the options that are available, but those are the ones that are most commonly used, probably the most realistic ones to use as an alternative to the H-1B. So circling back to the strategic focus, kind of what you need to be thinking about when you're thinking about these options. Again, what is your current immigration status? Are you here in the United States? Do you have a way to extend your current status? Is there another status that you can change to meet at least your short-term goals while you're working on longer-term options? What are your long-term goals? Do you want to be in the United States long-term? Do you want to employ this person long-term? Or do you want to work with them for 6 months, a year, figure out if it's a good fit? And then finally, how feasible are your options? How much risk are you willing to take? How many options are you willing to take at once? And that goes to how much time and how many resources you're willing and able to invest in the process. But it absolutely can be worth it. So next steps from here. I encourage if you or your employee were not selected in the H-1B lottery, I encourage you to have a conversation with each other. Have a conversation, be real, talk about what's going on, talk about what you're thinking, what you're feeling. Consult with an immigration attorney. Hopefully that's me, but consult with an immigration attorney who is qualified, licensed, knows what they're talking about, to talk about potential options for your particular situation. Plan for next year's H-1B lottery if necessary. We have already started a list of people who are interested in registering for next year's lottery. So this is April right now. We're talking about next March. So plan ahead for next year's H-1B lottery if you need to, and then work on implementing those short and medium and long-term steps, or so that you can eventually, ultimately, maybe sooner rather than later, meet your immigration goals. So if you have questions, as I said, please put those in the comments. I am happy to answer those if I can. You can also email us at info@sumnerimmigration.com. Looking to see if it's here, but it's not. And these are ways to stay connected with us. So you can scan this QR code and get access to all the different ways to stay in touch with us. This QR code is safe, by the way, to use. It'll take you to a web page that has a link, direct link to all of this. You can follow us on YouTube. You can follow us on LinkedIn. We have a company page. I personally, Emily Sumner, have a LinkedIn page that I post on frequently throughout the week. We are on Instagram and Facebook. We have an email newsletter that we publish once a month. It comes out the first Wednesday of every month. And we hope that you'll sign up for that. Visit our website that has a link to a lot of information about this, all of the options that we've talked about. Also has a link to set a consultation if you're interested. And I hope that you will stay in touch with us, stay connected, get connected. Let us know what questions you have. Let us know how we can help. We are here to help. We want you to, I know that it's frustrating. I know that it's stressful, the whole US immigration process, but we want to help you come up with a plan, a clear, concrete plan that may have multiple pathways, right? It may be that you pursue multiple options at the same time, but we want you to have a plan to help you as an employer, you as an individual employee, come up with a way to meet your US immigration goals, because there are options. So I hope that you will contact us. And that's all we have. So thank you so much for joining us for this webinar. I hope that you will visit our website to sign up for the next webinar and keep an eye on our emails and social media posts to learn about our upcoming webinars. We are happy to share information. We want to know what concerns you. We want to know that so that we can help you, help educate you, and help you feel comfortable as you navigate this really complex and sometimes intimidating process. My name is Emily Sumner with Sumner Immigration Law. We serve clients throughout the United States and throughout the world with family-based and employment-based immigration matters. Thanks for joining us.